Welcome back to the deep dive. Today, we're really digging into something big. Government transparency.
Yeah, it affects everyone.
Exactly. We've gone through the official source material on the Public Information Act, and, well, our mission here is to give you this shortcut, the definitive guide to understanding how public access laws actually work.
What you can ask for, basically.
Right. And just as importantly, what the government is, explicitly allowed to keep confidential.
And we should start with the main idea, the core takeaway. The law is generally on your side. It favors the requester.
Okay.
The basic principle is what lawyers call liberal construction. I mean, essentially, the sources are clear. Public information is meant to be available to all members of the public.
Liberal construction.
Yeah.
That sounds, well, good, but what does it mean practically for someone just trying to get a document?
It means if an agency is kind of on the fence, maybe 50-50, about releasing something,
Yeah.
the law defaults towards disclosure, towards letting you see it.
Ah.
The legislature's goal is transparency, maximizing it. The tricky part, and this is what we'll unpack, is finding that balance. How do you have accountability and protect necessary secrets? Things like personal safety or legal strategy, security.
That tension. Yeah, I can see how that would create all the exceptions.
Exactly. That's what drives almost every exception we're about to get into.
Okay, so let's unpack it then. We're going from that big general rule
Right. Available to all.
to the specifics,
Right.
how you ask for information.
Yeah.
And then, diving into that really fascinating kind of complex list of exceptions, the stuff the law
Let's
shields.
just do it.
So first step, making the request. Our sources confirm it must be in writing.
No casual phone calls. Won't work.
Right. You could use U.S. mail, email, hand delivery. Now, sometimes government bodies might approve other ways, like maybe a website portal or even a fax.
But they have to tell you.
Exactly. If they allow those other methods, they have to display that publicly, usually on a sign or, their website.
So you know your options. Okay, so you've sent it in. What happens next? This is where that common myth comes in.
Ah, the 10-day thing.
Yeah, everyone thinks the government just gets 10 business days. But here's the crucial part, the real insight from the source. The law actually demands the information be produced promptly.
Promptly. So that 10-day window isn't like a guaranteed waiting period for them.
Not at all.
They can't just sit on easy-to-find information until day 9. They have to produce it. Well, promptly, like now.
Exactly. Promptly actually has a legal definition. As soon as possible under the circumstances, that is, without delay.
Okay, under the circumstances. So complexity matter.
Of course, a huge request takes longer.
Right.
But the point is, if a governmental body is just, dragging its feet on something simple, they're violating the act, even if they get it done within those 10 business days.
Oh, okay. That really flips the script. And when they do respond, what about delivery? How do you get the info?
You've got options. Compliance means they either have to make it available for you to inspect or copy right there at their office.
Or
They can mail copies to you. And there's a third way, becoming really common now for efficiency.
a web link.
Yeah, an exact URL to the document online. But, and this is important, if they email you that URL, the email has to clearly state that you, the requester, still have the right to actually inspect the info in person or get mailed copies instead.
So they can't just sort of bury your right to physical copies behind a link.
Correct. That right remains.
Okay, so we know how to file, how quickly they should respond,
Mm-hmm.
but now the big conflict zone, exceptions. Where does the right to know bump up against privacy?
Right. Let's start with personnel privacy, Section 552.117 and 552.1175. This protects key info for current and former officials, employees, usually those in sensitive roles.
Like police officers, judges?
Exactly. Peace officers, judges, CPS workers. It protects their home address, home phone number, social security number, even info about their family members.
And what's really interesting here, from the sources, is the element of employee choice.
Yeah, absolutely. For many public employees, they have to actively choose, usually in writing when they start, whether to allow public access to that personal information.
It's not automatic disclosure.
No, it reflects a legislative decision, really. That public service, especially sensitive public service, shouldn't mean giving up all your home privacy. And here's a little nugget alert on that.
Oh.
While employees often choose about their address or phone number, school districts cannot require an employee or a former employee to choose whether to allow public access to their social security number.
Wow, okay, so that specific piece of data, the SSN, gets extra protection for school employees. They can't be pressured into releasing it.
That's right. It's specifically shielded from employer mandate in that context.
That's a very specific protection. Okay,
Yeah.
shifting from living people to historical records. What about vital statistics? Birth and death records?
Yeah, that protection is purely time-based,
Mm-hmm.
temporal. The law gets that these records are sensitive, but it sets expiration dates.
Help.
Birth records. They stay confidential for quite a while, until the 75th anniversary of the birth date.
75 years.
Okay.
And death records.
Much shorter. Confidential until the 25th anniversary of the date of death.
25 years. But what if?
Mm-hmm.
What if the person who died was never identified?
Ah, good question. In that case, the confidentiality period is drastically cut. The record becomes public on just the first anniversary of the date of death.
Only 1 year? Why so short?
Well, the likely reason is the strong public interest in identifying that person, right?
Wow.
And maybe helping conclude any investigations sooner.
Makes sense. Okay, let's move into sort of higher stakes government stuff. Strategy, litigation. How does that work?
The litigation shield, section 552.103. So yeah, that shield, it's really there to stop people from using the Public Information Act as like a sneaky backdoor.
A backdoor to get evidence they should be getting through the formal court process.
Precisely. Getting stuff outside of discovery rules in a lawsuit. But what's really key here is that this shield, it's discretionary.
I mean, the government doesn't have to use it.
Correct. They have the option to withhold info related to lawsuits, but, and this is critical, for the shield to even possibly apply, the litigation must be pending or reasonably anticipated
Yeah.
on the exact date you file your request. It's strictly time-bound, based only on the situation at that precise moment. If the case settles the very next day, poof, shield's gone for that request.
Wow. Okay. Very time sensitive. That makes sense. You wouldn't want to hamstring a live legal defense. Okay. Switching gears from civil cases to criminal investigations.
Yeah.
The law enforcement clause.
Section 552.108. Yeah, information held by police or a prosecutor. It can be withheld if releasing it would interfere with the detection, investigation, or prosecution of crime.
So protecting ongoing cases.
Exactly. And it also covers information from investigations that maybe didn't end in a conviction or deferred adjudication, closed cases that didn't go anywhere. It stops interference with police methods, witness safety, that sort of thing.
But surely there has to be some transparency, even early on, for public accountability.
Absolutely. And that's the crucial loophole, or maybe the mandatory transparency part. Section 552.108C.
What does it say?
It says that main exception does not apply to basic information about an arrested person, an arrest, or a crime.
Basic information like?
Like the stuff usually on the front page of an offense report. Name, age, address, the time and place of the arrest, what they're charged with, names of the arresting officers, that basic who, what, when, where.
So that has to be released promptly, even if the investigation is super sensitive.
Yes.
Yeah.
That fundamental accountability info is not optional. It must be released.
Okay. And speaking of risks the government faces, cybersecurity. That's huge now.
Definitely. Section 552.139 covers that. Information about computer network security, vulnerability reports, audits of system weaknesses, explicitly confidential.
Makes total sense. You don't publish the blueprint for how to hack your own systems.
Right. But let's look at something maybe less obvious, something physical. Why are photos of a house interior protected? Section 552.155.
Yeah, that seems oddly specific.
It's-
Interior photos.
It relates to tax appraisals. Those interior shots taken by county appraisers for property tax reasons, they're generally confidential. It's a residential privacy thing in that context.
But what if it's my house?
Then the confidentiality doesn't apply to you. The governmental body must give you the photo if you own the property when the picture was taken.
So you have a right to see the basis for your own property valuation.
Exactly. It's your fundamental right regarding your own property records.
Okay, before we get into compliance and costs, there's one really big structural piece we have to mention. An entire branch of government is out.
Correct. The judiciary. Courts are entirely excluded from the Public Information Act.
So the act applies to the governor's office, state agencies, legislature, but not judges and courts.
That's right. The PIA governs the executive and legislative branches. If you want court records, dockets, filings, opinions, that's handled by totally separate rules. Rules made by the state Supreme Court itself, Rule 12, usually.
Why the separation?
It's about the constitutional separation of powers, keeping the branches independent. Now, it's a narrow exclusion. If a court makes purely administrative decisions, like choosing a probation officer, that might still fall under the PIA because it's not core judicial work, not deciding cases, but the main function is separate.
Got it. Okay, so turning back to the agencies covered by the act, what about compliance? making sure officials actually know this stuff.
While the law tries, there's a mandatory training requirement.
For whom?
Elected and appointed officials covered by the Act, they have to take a 1-hour approved course on the PIA. It's a one-time thing, supposed to happen within 90 days of them taking office.
Okay, mandatory training sounds good, but
Yeah.
you hinted at a paradox.
Yeah, this is where it gets, well, astonishing, really. The training is mandatory, required by law. But
Yeah.
there's no specific penalty written into the Act for just not doing it.
Wait, what? Seriously? The law requires training, but there's no fine, no immediate consequence if an official just blows it off.
Pretty much. It's one of the crooks.
So where's the incentive? Why would they bother?
The incentive is basically deterrence, future risk. Officials are warned, that deliberately skipping the training, that could look really bad later if they get accused of actually violating the Act, like illegally withholding information.
So if you're charged with criminal negligence for denying access, prosecutors could say, and look, they couldn't even be bothered to take the required training.
Exactly. It shows a potential pattern of disregard for the law. It increases the risk down the line.
Okay, that makes a bit more sense, albeit in a roundabout way. Let's talk money. Costs. Always a friction point.
Huge friction point. Okay, so if your request is pretty small specifically, 50 pages or fewer of standard paper records,
Yes.
the only thing they can charge you for is the photocopy cost itself. Like 10 cents a page, whatever the standard rate is.
No labor charges for finding it.
Not if it's 50 pages or less of paper, but once you go over that, or if it involves electronic data that needs searching or manipulation,
Then the charges add up.
oh yeah. Then they can charge for labor time, overhead costs associated with that labor, computer programming time, manipulating data. It's all calculated based on specific rules set by the Attorney General.
And the government has ways to make sure people pay, right? Financial enforcement.
They absolutely do. Two key things. First, if the estimated charges are going to be more than $40,
Okay.
they have to give you an itemized estimate before they start the work. You have to approve it.
And second.
Second, and this is a big one for frequent requesters, a governmental body can actually refuse to give you new information if you already owe them money.
How much money?
If you owe more than $100 from previous requests where you accepted the estimate but never paid up.
So they can cut you off if you're racking up bills and not paying.
Exactly. It stops people from overwhelming agencies with huge requests they have no intention of paying for.
Okay, the ultimate stakes then. Penalties. What happens if an official just refuses access illegally?
Well, if they do it with criminal negligence, it's actually a crime. Criminal misconduct.
What kind of crime?
It's a misdemeanor, punishable by a fine up to $1,000 and potentially up to 6 months in jail.
So there are real teeth, potentially.
Yeah.
And for the citizen, the person trying to get the records, what's their remedy if they're denied?
The main civil remedy is called a writ of mandamus. Basically, you sue and you ask a court to order the governmental body to release the information, compel them.
Okay. So wrapping this deep dive up,
Yeah,
it feels like we've peeled back a lot of layers.
definitely.
The Act demands, a genuinely prompt response, not just waiting out the clock. It forces officials to think about their own privacy choices. It carves out necessary space for legal strategy and security.
And yeah, those surprisingly strict rules about handling costs and dealing with people who don't pay their bills.
Right. I think the biggest takeaway for me is just how much of a balancing act this is.
It really is. It's not just open or closed. It's this dynamic, section-by-section effort to weigh transparency against other legitimate needs, personal safety, fair trials, infrastructure security.
Trying to maximize accountability, but being realistic about what needs protection.
Exactly. Protecting specific, defined interests while keeping the default set to open.
Which brings us perfectly to our final provocative thought for you, the listener, to consider. Thinking about that really strict separation of powers we discussed.
The judiciary being completely excluded from this act.
Right. How might the fierce independence of the judicial branch, operating under its own access rules, ultimately shape or influence the future boundaries of information access for all the other governmental bodies, especially as, new legal fights and technologies keep popping up?
That's a really interesting question to ponder. How does one branch's autonomy affect the whole ecosystem of transparency?